Federal versus state powers under the United States Constitution. Each state in the Union retains its own legal system and decides the vast majority of cases coming before the courts. The laws and systems can differ radically from state to state. Some states, such as New York, are derived from English common law. Some, like Arizona and New Mexico, are derived from Spanish civil law, and Louisiana retains many features of the French system from which it originates. A parallel legal system is operated by the federal judiciary across all the states. Under Article 3 of the Constitution, which defines the scope of judicial power, federal courts have limited jurisdiction. State courts are the default setting for most cases in the United States. However, through the Supremacy Clause, the U.S. Constitution provides power to the federal court to strike down state laws that are deemed unconstitutional. So in this area, federal law rules supreme. Federal courts settle real cases and controversies, and are restricted from making advisory opinions. There must be a real dispute between adverse parties for the case to be heard in a federal court. Federal courts can only decide actual cases with binding outcomes. If the court's decision can be overruled by an executive official, then this is an advisory opinion and does not qualify for consideration by the federal court. Federal courts are often asked to nullify state statutes as unconstitutional. If the statute in question is dormant, and there's no reasonable likelihood for it to be enforced, then the issue is not an actual case or controversy and cannot be heard in federal court, regardless of whether the statute is constitutional or not. The case must be timely, and the actual case or controversy must be current to qualify for the federal court's consideration. A case challenging a proposed law that has yet to be passed is not ripe, and cannot be heard until the law is actually passed. On the other end of the scale, a case that has been settled is characterized as moot. As such, it will be dismissed by federal court. An example is the case of a prospective law school student challenging the school's admission policies on constitutional grounds. The case was dismissed by federal court, as the student had been admitted by the time the case reached the court. However, if the injury is capable of repetition to that particular plaintiff, the case is not moot, and it can be heard. As example is the Roe v. Wade abortion case, which was moot by the time the case reached the court, as the baby had already been born. As the mother could become pregnant again, repetition to the same plaintiff was possible, and the case formed an actual controversy that qualified for the court's consideration. Another exception allowing moot cases to be heard is where the case is moot for the named party in a class action, but is still alive for another member of the class. If the issue has been closed, such as a jail sentence served, then the case is moot unless there are collateral consequences, such as a criminal record that the plaintiff wishes to have removed. In a case requesting an injunction, it would be simple for a defendant to claim the case is moot by simply ceasing the offending activities the day before the case is heard in court. In this situation, known as voluntary cessation of illegal activities, the court looks to whether there's any reasonable likelihood that the activities could be resumed. Even when the defendant corporation has gone out of business, the case is not moot if the corporation still has a license to resume its operations. A plaintiff cannot simply challenge a law or act in federal court just because they don't like it. A plaintiff requires standing to sue, and this means she must show injury in fact, causation, and redressability by the court. The injury must be personal, to the plaintiff, must be caused by the defendant, and the remedy requested of the court must redress the injury caused by the plaintiff. Being a citizen of the United States is never sufficient grounds to establish standing. The citizen must be a personally injured citizen, and must satisfy the rules of standing. The same applies to taxpayers. However, there's a very narrow exception for taxpayers that are challenging a taxing and spending statute of Congress and claiming it exceeds a constitutional limit. A case brought by the actual fighters in the dispute is considered more worthy of the court's decision than one brought by a third party. There is an exception, however, when the party bringing the suit is in a special relationship with the injured party, such as doctor and patient, and the injured party is unable to bring the suit themselves for some valid reason. Standing is required by organizations as well as individuals. When the organization is suing on behalf of its members, the injury may be characterized as non-personal to the organization itself. The court could require the members to bring the suits themselves. In this situation, the rule is that at least one member of the organization has standing. The injury has to be germane to the purpose of the organization, and the individual's presence is not necessary to administer the relief. The United States Supreme Court does not have general jurisdiction over all cases from state courts. It will not and cannot interfere in state matters that do not involve federal laws or matters that can be adequately resolved in state courts. For a case to reach the United States Supreme Court from a state court, it must satisfy 4 criteria. Firstly, it must involve a federal question. Secondly, it must have been exhausted by the state court system and result in a final state judgment. Thirdly, the judgment must be from the highest court in the state. And fourthly, the matter must be impossible of being settled under state law. If the case involves a state law and a federal law, but the issue can be resolved under state law, then the matter cannot be heard in the United States Supreme Court. The principle here is that the states manage and control their own cases, and only where necessary and appropriate will the Supreme Court of the United States have the power to overturn a state court decision. If the Supreme Court's decision would have no bearing on the outcome of the case, i.e., when the state court and the Supreme Court would reach the same decision, or the state could overrule the Supreme Court's decision on independent and adequate state grounds, then there's no point in the Supreme Court hearing the case, and the case does not qualify for Supreme Court consideration. Out of respect to the state courts, the Supreme Court judges will often force issues through the state court system before they're prepared to consider the case. They effectively abstain from hearing state court cases until the state courts have had a chance to decide the matter on state grounds. The Constitution provides for one state to sue another state in federal court, and a private party is able to sue his own state in his own state court. However, following the Revolutionary War, the state of Georgia was indignant that it was being sued by an individual from another state, and was subject to sanction by a federal judge. Georgia championed the 11th Amendment that now forms a bar preventing private parties suing states in federal court. So, a private party cannot sue a state in federal court unless a state expressly consents or Congress passes legislation allowing a private party to sue. An exception to this rule was carved out following the Civil War and the 14th Amendment, which was aimed at forcing all the states to provide certain rights. A private party can sue a state that is failing to offer equal protection and taking without due process of law in violation of the 14th Amendment. There's another loophole that is often used by private parties wishing to sue a state. Although a private party is restricted from suing the state itself, she can sue an individual officer of the state, and a federal injunction preventing the state officer from taking unconstitutional action will be binding on the state. Sovereign immunity is the doctrine behind the saying that the king or the queen can do no wrong. The state is able to invoke sovereign immunity when facing a suit from one of its own citizens. However, in many cases, governments have waived this immunity to allow for suits. In some cases, an individual may technically appear as a defendant on the state's behalf. Congress does not have the power to force states to waive their sovereign immunity and hear cases from their own citizens in their own state courts on grounds that this would violate principles of federalism. The exception to this rule is enforcement of the post-Civil War 14th Amendment, providing equal rights to citizens of all the states. The Constitution leaves police powers and other rights with the states. But under the federal system of government, the powers of each state is limited. Of course, all the powers explicitly given to the federal government in the enumerated list in the Constitution are beyond the powers of the states. Other powers are explicitly taken from the states by the Constitution. These include the right to coin money, the right to declare war, or conduct foreign relations. All these powers are provided to the federal government at the exclusion of the states. The Constitution declares itself to be the supreme law of the land. When the federal government exercises its legitimate powers, it preempts or trumps state laws that are inconsistent. If it's not possible to comply with both the state law and the federal law at the same time, then the state law is rendered void. The federal law does not have to declare that it preempts those of the state. It doesn't matter if the state law was passed first. It doesn't matter if the federal law is irrational, unreasonable, or harmful, and the state law is wise. It doesn't matter if the state law was enshrined in the state constitution and the federal law was part of some obscure statute. Federal law is supreme and will displace inconsistent laws of the state and local governments. It's important to remember here that the federal government has powers over only certain matters, such as interstate commerce, and that the states retain powers that are not enumerated and provided to the federal government. So the state reigns supreme in areas where it would be unconstitutional for the federal government to legislate. Also, state laws that are different but complementary to federal laws are not preempted. For example, if a federal law requires seat belts for the front seats of all automobiles, but a state law requires seat belts for rear seats as well as front seats, then the state law stands. It's different, but it's not inconsistent. States can't sue, tax, or regulate the federal government without the federal government's consent. However, the federal government does not need to request state consent before suing, taxing, or regulating the states. The Constitution used the Privileges and Immunities Clause to unite the Federation of States. A state cannot treat a citizen from another state like a citizen from another country. A state has to treat all citizens of other states with the same privileges and immunities as it treats citizens of its own state. For example, a state cannot require residency within the state for admittance to the state bar. Citizens of other states have the right to admittance as they have to be treated equally. Note that this is focused on U.S. citizens. It does not apply to alien residents or corporations. There are some limits to the extent of the Privileges and Immunities Clause. A state can charge out-of-staters more for hunting licenses, as this is merely a recreational activity and doesn't qualify as a privilege or immunity. A state can restrict its own welfare benefits to citizens of the state and treat state employees differently from non-state employees. We know that the Constitution provides Congress with broad powers to regulate interstate commerce. We also know that a federal law is supreme and would trump a state law that is inconsistent. However, what happens when the state regulates in an area of interstate commerce and Congress is silent? There are no federal laws in place to preempt the state law in this situation. This is known as the Dormant Commerce Clause, as Congress is sleeping, has not acted in this field. It's also known as the Negative Commerce Clause, as it blocks states from regulating, negates their attempts to establish trade barriers. The rule is that states can implement legislation that directly or indirectly affects commerce with other states, unless their law discriminates or unreasonably burdens interstate commerce. A state law that favors its own citizens and discriminates against those of other states is per se invalid. Free trade between the states was recognized by the framers of the Constitution as beneficial to the whole federation. Powers to regulate was given to Congress to prevent the states from erecting trade barriers that benefit their own citizens at the expense of others. Economic protectionism by the states is unconstitutional and is not tolerated. There is an exception where the state is participating, buying or selling goods on its own behalf. In this situation, the state is not acting as an external regulator, but as a participant in the market. The state is able to sell at preferential prices to its own citizens, and can practice other discriminatory behavior that burdens interstate commerce, when the state is participating in the marketplace as a buyer or a seller. The state is also allowed to provide subsidies, money, to its own citizens, without offering the same opportunities to citizens of other states. Although taxes are treated as regulation, the state is not restricted from investing and spending its money within its own state boundaries. Also, when the state is exercising its police powers and acting for the welfare of its citizens, it can regulate, and regulation that affects interstate trade can be held valid if the state can show compelling need and that there is no better alternative method of achieving its goals. Only in the most compelling cases does regulation by the states that forms a trade barrier pass the strict scrutiny of the federal courts. Of course, Congress has the power to regulate interstate commerce, so Congress can authorize regulation by the states. Congress can control state taxation through its taxing and spending power. Taxation is a form of regulation, so state taxes that form trade barriers are subject to the federal interstate commerce power. States do impose their own taxes on their own citizens and companies, but taxes can be held violations of the Commerce Clause when they discriminate, unreasonably burden, or otherwise form trade barriers with other states. States are restricted from taxing activities in other states. Taxes levied on commerce must be proportional to the commerce undertaken within the state itself. Flat, unproportional taxes on corporations are unconstitutional. Trucks and trains operating within the state can be subject to state taxes, but the state is restricted by the Dormant Commerce Clause from taxing trucks and trains that are merely passing through in pursuit of interstate commerce.